Good morning, everybody. Good morning. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Low TV. Before I begin, y'all already know the routine. If you haven't already, please go ahead and hit that like button, hit that subscription button, and turn that notification bell on. And I will give y'all a second to do that. All right, so this will be part two of just a basic preview of the ebook. This is where the cover pages for the ebook is actually going to go right here. I believe the ebook is finished, but I just want to go over it and show y'all how it looks. So just in case that if y'all can think of anything that I might need to add to the ebook, then I can. But this is just reservation of rights, purposes, and disclaimer of the author, which is me. So let's go down here. This is the table of contents. I try to make this as short as I possibly can. So let's see. I'm gonna show y'all everything that's in the ebook. Table of contents, and in the addendum section, these are all sample copies of requests for admissions, requests for productions, interrogatory. So in other words, these are tools that you use in discovery. These are the tools that I think that are relevant in regards to 42 section 1983 lawsuits when you're going through discovery. You may want to use some other rules. I haven't, as of right now, I don't have any other use for any other rule, any other discovery rule. As of right now, I can't really think of any right now. So that's why you only see requests for admissions, requests for productions, and interrogatories. So let's see. Sample objection. This is just sample objection. I already showed this to y'all in the previous video. But any type of objection you have, you bring it by a rule within the federal rules of evidence. So in this particular rule, well, I'll show it to you on page 26. Where in this particular objection, I want to say rule 402. We'll go down, sample initial disclosure, because prior to going to discovery, you have to do the initial disclosures. I think it's rule 26. Can't really sure. I'm not really sure, but I have to go in and look. But anyway, this is just, why is that looking like that? It looks like an error. Yeah, it is an error. So I have to go back and fix that. Yeah, I'm gonna have to go back and fix that, because this right here is supposed to be on this page. This complaint part, page one, is supposed to be up here. But anyway, so we're just scrolling through it right now, y'all. Just scrolling through. These are the statutes required to be alleged in the complaint. They're in bold. I try to make this stuff very simple. Anything that's in bold like this, you need to read it. Read it for yourself, and then go read cases on it if you're confused. I would read cases on it even if I'm not confused. I would read cases on it just for clarity, just to make sure that I understand it. This particular section, I added this. Elements of common law torts for the District of Columbia. So what I did was I went to find cases within the District of Columbia, the federal court, for false arrest and imprisonment, assault and battery, intentional infliction of emotional distress. I think there was one other way, malicious prosecution. That is not a complete list, okay? There are more. There are potentially more, but these are the main ones, the basic main ones that I believe that are litigated a lot. All right, so when you're in federal court and you're litigating these types of causes of actions, you're going to do it under dependent state jurisdiction. All right, which is, let me go back up. Dependent state jurisdiction, I think it's this boy right here. Yes, dependent state jurisdiction is also called supplemental jurisdiction, so it's going to be under this statute right here. This is why you have to allege that statute in the complaint. Let's go down. And I'm going to just read some of this stuff to y'all, because all offenses and crimes have elements. The elements are the facts, the ultimate facts, the ingredients. What is it? The ultimate facts, the ingredients, the prerequisite elements, whatever you want to call it. I like to use the term ingredients because I think that it describes it better. So, for example, the ingredients for a valid false arrest claim in the District of Columbia are: 1, the detention or restraint of one against his or her will, and 2, the unlawfulness of the detention or restraint. So on and so forth like that. And then there's cases right here in support of that contention. Here's another one, the ingredients for an assault or battery under so-called DC law, or let me see, where is it at? Right here. It's right here. An assault is an intentional and unlawful attempt or threat, either by words or by acts, to do physical harm to the victim. So in other words, when somebody assaults you, they don't even have to touch you. They can point a gun at you and say, I'm going to shoot you. That is assault with a deadly weapon, if you ask me. Another one would be battery. I used to think that battery, that physical contact was an element of battery, but it's not. So right here, the ingredients for a successful, or in other words, a valid cause of action for battery under DC so-called law is an intentional act that causes a harmful or offensive bodily contact. It is elementary that an individual need not touch a victim to be liable for battery. And there it is right there. They're reciting the treatise on it, restatement, torts, so on and so forth like that. But let's go down. I'm just giving y'all a brief overview of this stuff. Read these footnotes, y'all. I don't know how many times I'm gonna say this, but I'm gonna keep on saying it. When you purchase this ebook, if that's what you're gonna do, read the footnotes. They're gonna help you out a lot. That is why I added them in here, and to make it look a lot neater. Read the footnotes. Read the footnotes. Read the footnotes. If you wanted to, sue for malicious prosecution, because this happens a lot, then the ingredients or the prerequisite elements or the ultimate facts would be something like this in your complaint. I'm going to call it the ingredients, though. The ingredients that you need is: 1, the defendant's initiation or procurement of a criminal proceeding against the plaintiff; 2, the absence of probable cause for the proceeding; 3, malicious intent on part of the defendant; and 4, termination of the proceeding in favor of the plaintiff. So all of these, if you wanted to pursue a valid cause of action against a defendant police officer in the District of Columbia in federal court, you need to have all of these elements right here. So let's go down. This is chapter 1, blah, blah, blah. Chapter 2. Just going over this stuff, y'all. See how neat I got this stuff for y'all? I try to make this extremely simple for y'all to understand. All right. For example, especially this one right here. I did some more researching when I found this case right here. So, because I want y'all to understand like what probable cause is and how probable cause is decided, if whether or not it existed or not. So it says, whether probable cause exists depends upon the reasonable conclusions to be drawn from the facts known to the arresting officer at the time of the arrest. Okay, now that's true. Okay, it also depends upon the particular statute that the officer is alleging that you violated, because that particular statute is going to have elements in it. And if you factually meet all of the elements in that statute, then as a matter of law, if you were arrested right then and there, that would be considered a lawful arrest. All right. Probable cause to arrest depends upon whether at the moment the arrest was made, the facts and circumstances within the arresting officer's knowledge and of which they had reasonably trustworthy information were sufficient to warrant a prudent man in believing that the suspect had committed or was committing an offense. So on and so forth, just like that. I make this stuff extreme. I did all of the work for y'all, all right, in regards to drafting this. Now, what you need to go and do, in other words, what I mean was I found all of the cases for you just by doing some research, all right? So what you have to do is you need to go and read these cases, and you do not stop reading them until you understand them. Read, 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 read. If you do not want to read, then this shit is not for you. I'm sorry. It's not for you. Let's see. Let's go down some more. Most of the ebooks are going to look like this. I think this is a very good example. So I'm going to try to keep them just like this. I'm going down here. I'm addressing the shotgun pleadings. The addendums. Let's go to the motions. Request for admissions. This is a sample. This is how my request for admissions look. All right. And then just to, make this a lot easier for you, I cite it right here at this footnote right here. Go to 67 and you'll see blah, blah, blah. There's a case right here. Federal Rules of Civil Procedure Rule 36A1 permits a party to serve blah, blah, blah. These are requests for admission. All right. Request for admissions. It's a certificate of service. Request for production. Same thing over and over and over and over. Interrogatory. See how simple this stuff is, y'all? I went and did all of this stuff just to make this stuff completely easy for y'all to understand. So the only thing you have to do is just make sure you get the caption right, the parties right, the case number right. I've cited the rule for you. Here's a case in support of it. So if you're in the District of Columbia, it's good. It's good. Objections. Now, if you wanted to object under another rule, you could, but you need to keep it just kind of looking just like this. You want it to look very simple and just short and straight to the point. You don't want to confuse the opposing parties, and you don't want to confuse the court. All right, keep this stuff very simple, y'all. Initial disclosures. I gotta go and fix this. Looks like there's an possible error in here, so I want to make sure I fix that because I don't need no mistakes in here. And what's the last thing I got in here? I don't know why that looks like that because I know I fixed that, but I'm gonna have to go and check because I might have didn't. So I'm gonna go and check that out. A synopsis. All right, I'm gonna read. I'm gonna actually read the case synopsis to y'all. The sample complaint below is a fictional scenario of an unlawful traffic stop, aka unlawful non-custodial arrest, and assault and battery created by the author to further aid pro se litigants in understanding of how to draft their complaint. The ultimate facts, aka allegations, aka ingredients, aka avertments used to support your cause of action are in the color blue. The elements of the common law tort, false arrest, and assault, I got to go and fix that because we got assault and battery in here too, so I got to go and fix that. Assault and battery in the District of Columbia are in purple, all right? To establish a valid claim, aka cause of action for false arrest in the District of Columbia, you must plead facts that show 1, detention or restraint against one's will within the boundaries fixed by the defendant, which is the one you're suing, and the unlawfulness of such restraint, or in other words, the unlawful detention, i.e. no warrant, no probable cause, no reasonable suspicion or consent of your person for any length of time by 3 actual force, fear of force, or words. All right. Moreover, to reaffirm my contention that any time you are not free to leave, you are arrested, I have provided the following excerpt. An arrest is a seizure under the 4th Amendment. And there's the case. Moreover, a seizure of a person can take the form of physical force or a show of authority that in some way restrains the liberty of a person. In total, the crucial test in deciding whether a person has been seized is whether, in view of all the facts and in view of all the circumstances surrounding the incident, a reasonable person would have believed he was not free to leave. So based on the facts and circumstances surrounding everything, would a reasonable person reasonably conclude, based on those facts and circumstances, that she or he is not free to leave? All right. To establish a valid claim, aka cause of action for assault. Did I do that again? I think I did. I gotta go and fix that. Yeah, I did. Let me go back up and check. I'm sorry, y'all. False arrest. Okay, no, I did it right. For assault in the District of Columbia, you must plead facts that show in intentional blah blah blah. Y'all get what you get where I'm going here, man. I don't want to make this video any longer than what it needs to be. But this is going to help y'all out a lot, man. It is going to help you out a lot. All right, so what I did was everything in blue are the ingredients. All right, the ingredients that supports why I'm suing this police officer. All right, and everything in purple supports. I don't even know how to word this without confusing y'all. Give me a second, y'all. Let me get my thoughts together. I'll be right back. All right, y'all. I'm back. Sorry about that. Back to it. So everything in blue are basically the facts, aka the ingredients that I'm using to support my cause of actions. All right. Same thing with with the purple. However, it's a little different. The purple is a little different because I want to use this to point out the Fourth Amendment violation. All right. So right here, this right here, it says plaintiff avers that about 5 minutes later, an MPD patrol car with its blue lights flashing then began driving behind plaintiff. Okay, this right here, this allegation right here, all right, allows me to reasonably conclude that I'm being pulled over. And since I'm being pulled over, or whatever you want to call it, since I'm being arrested, I'm going to say arrested. Since I'm being arrested, this allows me to reasonably conclude, because I did not consent to this, that the Fourth Amendment of reasonable suspicion or probable cause applies. All right. Down to this. Plaintiff avers that the defendant then exited his patrol car, approached plaintiff's truck, and then asked plaintiff, "Do you know why I pulled you over?" This also right here supports my contention that I have been arrested. And since I have been arrested, reasonable suspicion or probable cause is applicable. I'm detained. I'm not free to leave, or so to speak. You see what I'm saying? So I'm arrested. All right. Then this is something that I would say. If a police officer asks me something like that, this is what I would say. Plaintiff avers that he then politely replied, "I do not answer questions. Am I free to leave?" See that? All right. And then the officer would probably say something like, this is a fictional scenario, so this didn't really happen, but if it did, then you need to sue him for it. But anyway, plaintiff avers that defendant then replied, "No, give me your license, insurance, and registration," with an authoritative and assertive tone of voice while quickly removing his hand from his holster, and then immediately pointing it up. Supposed to be handgun from his holster, and then immediately pointing it at plaintiff with his finger on the trigger. That's what it's supposed to be. All right. The reason that is in there is because that is evidence of assault and battery right there. The doing of it, he didn't touch me. He didn't have to touch me. But the fact that he did that is evidence of assault and battery. Does that make sense? I'm suing for assault and battery. So I need something in here to substantiate. In other words, I need some elements, some ingredients, some facts in here to show why I'm suing for assault and battery. And these are the facts right here. This is one fact right here. These facts right here in this paragraph. And they're going to edit this. But anyway, I'm not going to go through this whole thing, but I'm just trying to give y'all some ideas of how to understand this stuff, man. So that's why I draw the distinctions in different colors. Hopefully this helped. If it doesn't, y'all let me know, and I will just come up with another way to do it. But that'll be the end of the ebook right there. It's very simple. This one is looks like about 47 pages. I think 47 pages is accurate. I don't think it's going to be any longer than that, at least not this ebook. Any type of ideas that y'all might have in the future or whatever to make it better, please let me know. Or if any I think of them, you know, I'll add them to the book, and the book will probably be longer. But other than that, I think this is pretty good. So hopefully this stuff helps y'all, man. I made this super easy for y'all, man. Super easy. Let me go back up. I gotta go and fix these errors in here. But that'll be it, y'all. The Supreme Litigant is out. Peace.